This is Anisha Babu. This channel, Law Point, is all meant for common people to know their law. Our legal sessions will be handled by Ms. Praseena Elizabeth Joseph, Advocate on Record, Supreme Court of India. In India, will is not often prepared as they see with respect to other legal documents. Are you afraid to make a will? Then our today's session is on need for making a will. So let's watch.
Hello friends. Many individuals are unsure and confused about making a will. Some even think they might die sooner if they make a will. Their unwillingness to accept death as an inevitable reality is a common reason why many die without leaving behind a will. Sometimes the realization that wills are necessary comes too late, such as when there is a death in the family, or a disability, or when they become senior citizens. It is interesting to note here that Princess Diana, when she died at the young age of 36, she left behind a will. So, I thought of addressing all aspects related to making a will in today's session. Obviously, the question of making a will comes only if you have movable or immovable properties under your ownership to be passed on to your loved ones. As per the law of wills defined under the Indian Succession Act 1925, will is defined as a legal declaration of the intention of the maker of the will, who is called a testator, with respect to the property which he desires to be carried into effect after his death. To put it in simple words, it is a legally valid document which lists out how you want your properties to be handled after your death. In India, every major means a person who is not a minor and has attained the age of 18 years as per Indian Majority Act. Every person who is a major and is of sound mind can make a valid will. A will needs to be made voluntarily and out of free will. But if he is of unsound mind, or if he is under influence of drugs or intoxication, or by force or coercion or by undue influence, if anyone is forcing a person to write a will, then that will is not valid in the eye of law. Now, it's very important to note that will is such a document which is valid even if it is not registered. So, registration of will is not mandatory. If you are writing a will in a piece of paper signed by the person who is making the will, who is called a testator, and signed by two witnesses, then it's a valid piece of document. Let me now throw some light on the advantages of making a will and also consequences of not making a will. If you make a will, you can decide how you would like your movable properties like bank balances, shares, fixed deposits, car, jewelry, etc., and your immovable properties like land, house, etc., to be transferred upon your death. You can decide who gets what and how much. You can also fulfill your spiritual desires like creating a trust, donating to causes like orphanages, temples, old age homes, hospitals, educational institutions, NGOs, etc. A will becomes enforceable or can be implemented only after your death. So you don't have to worry whether your intended beneficiary will have a claim on your property while you are alive. So, in your will, for example, in your will, you state that your so and so property will go to your niece after your death. But if you feel like selling this property in your lifetime, you are free to do that. Your niece cannot object to your selling your property because the will takes effect only after your death. If you at any time wish to withdraw or revoke the will, you are free to do that. There is no restriction on how many times you can make a will. However, only the last will made before your death will be implemented or it will be enforceable. After the death of a person, there are two possibilities of transfer of property. If a man dies leaving behind a will, then the succession is called testamentary succession. And if a man dies without a will, then the succession is called intestate succession. If you die without making a will, then the law of the land will take its course and there is no guarantee that your properties will be distributed in the manner that you desired. If there is a will, then a lot of court cases and family disputes can be avoided. Otherwise, after your death, your loved ones, instead of mourning for you, might be fighting in a court of law for your hard earned assets. Not only that, your property may be transferred to someone whom you did not intend to share it in the first place, such as your ex spouse with whom you had a bitter divorce, or children who neglected you in your old age, or your immediate relative with whom you had fought your life with. So, be wise and make a will at the earliest so that you are in charge of your asset allocation after your death. Else, the law will take its course. To sum up, today I covered what is a will, the need to make a will, and the consequences of not making a will. In my upcoming sessions, I'll be covering how to make a will and how to execute a will. Keep watching.
Thanks for watching. Catch you soon.